I want to say good evening to everybody. I'm very happy to see you all here. And on behalf of First U, I'd love to welcome you to this special event. My name is Lisa Sharp, and I am the president of the board of the First Unitarian Congregation of Ottawa. I've also been a lawyer in family and immigration law for the past 15 years. Tonight, we are examining how racism is alive and well in the Canadian criminal justice system. During law school in 2001, I first learned about the overrepresentation of Black and Indigenous persons in our prisons. Specifically, I remember hearing about the RDS case, which took place in 1993 in Halifax, Nova Scotia. In this case, a 15-year-old Black youth riding his bicycle was arrested and charged with assaulting a white police officer. The case was heard by Nova Scotia's first Black judge, Justice Corinne Sparks. She made the decision to acquit RDS of the charges. For those of you who didn't study criminal law, an acquittal means that the prosecutor failed to prove his or her case beyond a reasonable doubt. During her oral reasons and her decision, Justice Sparks made some comments about the existence of systemic racism in the handling of cases by the Halifax police against non-white accused in that community. The Crown prosecutor got upset and appealed the decision to the Nova Scotia Provincial Appeal Court, accusing the Black female judge of being racially biased against the white police officer who had made the charges. They agreed and they overturned the acquittal of RDS. Luckily, this decision was then appealed to the Supreme Court of Canada. They overturned the Nova Scotia Appeal Court's decision. The Supreme Court of Canada confirmed that the acquittal of the young RDS, underscoring that the original judge made a totally appropriate decision, taking into account her own experience of racism in the community. This case led me to write a research paper identifying how systemic racism is present at every step of our criminal justice system. Since becoming a lawyer, I have represented refugees being held unfairly in our detention centers. I've conducted research on Canada's detention of unaccompanied minors who were 12 to 16 years old. That's refugee children being held in our detention centers. Most recently, I work in child protection family court, and I was representing an Innu mother in a 23-day trial where I presented arguments in which we identified dozens of specific racist practices that the Ottawa Children's Aid Society has used in my client's case. As well, we relied on the Truth and Reconciliation Commission calls to action with respect to the provisions recommended to improve our child protection system. This case and others like it have further opened my eyes to the ongoing systemic racism in our justice system. As we know, knowledge is power, and we are thrilled to have with us this evening 4 speakers who will share their experience and knowledge with us. First of all, I'm going to introduce them all now, and then they will each speak in turn. First of all, we have Barbara Jackman. She's a Canadian lawyer specializing in immigration and refugee law, with a particular emphasis on cases involving national security, domestic and international human rights, torture and other cruel or unusual punishment, allegations of membership in and/or support of terrorist organizations, the rights and protections afforded by the Canadian Charter of Rights and Freedoms, and Canada's responsibilities under international treaties. She has been described as being one of Canada's most effective advocates for immigration and refugee rights. Second, we have Matthew Behrens. He is a writer and community advocate with the group Homes Not Bombs. He has spent the past 2 decades working on security certificate and extradition cases, building networks of support for refugees fighting deportation, and providing support to women behind bars for defending themselves against male violence. In addition to working with Indigenous nations fighting megadams from Muskrat Falls in Labrador to Genpeg and Kiosk in northern Manitoba. He also works with Indigenous detainees under indefinite detention because they have been wrongfully labeled dangerous offenders. The next speaker we have is McSorley. He joined the International Civil Liberties Monitoring Group as the coalition's national coordinator in November 2016. Combining his passion for civil liberties and social justice with his background in journalism, policy analysis, and communications, Tim explores the impact of government policies and works with allies and partners to fight for change. Previously, Tim was the coordinator for the Media Co-op Independent Media Network and the Dominion magazine. He also served as coordinator for the Voices Voix Coalition, defending the right to dissent and protecting democratic rights in Canada. Azeezah Kanji is our fourth speaker tonight. She is a legal academic and writer based in Toronto. Azeezah's work focuses on decolonial and critical race feminist approaches to international law, Canadian constitutional law, and the war on terror. Her writing has appeared in the Toronto Star, National Post, the Ottawa Citizen, Open Democracy, Roar Magazine, iPolitics, Policy Options, Rabble, and various academic anthologies and journals. Azeezah also serves as Director of Programming at Noor Cultural Center, a Muslim educational, religious, and cultural institution dedicated to gender equality and social justice. I'm so pleased to welcome all of our speakers tonight, and we'd like to start off tonight with Barbara Jackman. So Barbara, if you could turn on your video, and you will be our first speaker. And by the way, we will take questions at the very end of all the speakers.
Can people see me?
No.
And hear me?
Yes, yeah. I can see you and hear you, yes.
Okay. I think it's just you, Lisa.
Okay, I don't know why, yeah. But good.
I can see everybody else.
Okay, good.
Okay. Anyways, I'm going to sort of focus on Mo Harkat's case, because I think it's emblematic of the kind of Islamophobia that has developed after September 11th, and that the courts just can't give up in the way that they deal with people. So most of you probably know a fair bit about Mr. Harkat's case, but let me just briefly cover a couple of things. The core allegations for him are that he was running a guest house for Ibn Khattab in Pakistan, and that because Muslims went through that guest house at a time when young Muslims from all over the Middle East were going to fight the good fight in Afghanistan, because those Muslims were going to end up in Afghanistan, he participated. They actually found that he was complicit in terrorist acts because of running the guest house. That the court has said there has to be some link between the person's activity and the actual crime. And this is an issue that's now before the Supreme Court. Before the federal court in Mr. Harkat's case. So the court will have to decide it. But at the moment, the minister has said that he can be removed from Canada because he was complicit in terrorism because he ran a hotel in Peshawar, Pakistan. That was the principal finding that they made against him. They also said he used sleeper tactics because he was careful about how he behaved when he was in Canada, and that he associated with people believed to be extremists. The association with people believed to be extremists is particularly problematic because one of the people he was said to be associated with had been tortured, and one of the first judges on his case decided not to pay attention to that person's secret evidence that was never disclosed. But then the next judge that had Mr. Harkat's case did pay attention to it, appears to have paid attention to it, even though it was obtained by torture. But in terms of his contacts, the kind of help that he was giving them, the association with extremists in Canada, was helping refugee claimants get through the refugee system, essentially. So I know from doing other cases that it's a house of cards. Like, there were allegations against some of my other clients that they were involved with certain people. And then later on, I came to know those people as clients. Like, they returned to Canada, or they had been, and they weren't the terrorists that CSIS was pretending they were, CSIS was asserting they were, but because they were not involved in the proceedings, the assumption was CSIS says they're terrorists, they're terrorists. And of course, none of them were in Canada to be able to bring them to court to have them testify at the time those cases were going on. So I mean, with Mr. Harkat, the men that he was alleged to be involved with were not in Canada. It's not like he could call them up and say, would you testify to help me? Those findings against Mr. Harkat both upheld the security certificate and formed the justification for Canada to send him back to face persecution in Algeria. It's important to note I think, that in Hassan Omre's case, a different judge, Hassan Omre had links to Ibn Khattab, who was an insurgent leader in Chechnya. That's what Mr. Harkat was alleged to have, the same kinds of ties. So Hassan Omre was found not to be a terrorist because Justice Mosley didn't accept that Ibn Khattab, an insurgent, was in fact a terrorist, and he didn't accept on the evidence that he was linked to Osama bin Laden. In fact, he found that because Hassan was connected to Ibn Khattab, he likely wasn't connected to Osama bin Laden. What Justice Noel did when he dealt with Mr. Harkat's case was the opposite. He decided that because people share an ideology, they're all part of the bin Laden network. So it would be like saying because there's conservatives in Germany, they're part of a network that takes in Canadian conservatives because they all share a conservative ideology. That is the finding of the court in Mr. Harkat's case. It is incredibly, I don't know what word you would use for it, dismissive of the individual beliefs of the beliefs of individuals. Like, instead of looking at the beliefs of individuals, all you do is find the connection. And once you've got the connection, there's an assumption that you're a terrorist and you can't ever overcome it. And I think Mr. Harkat's case shows that kind of Islamophobia in the sense that we're 18 years running from the time the proceedings against him started, and they are still maintaining strict conditions on him. When he was first released from, first of all, he was detained in December 2002 until June of 2006. That detention the entire time was unlawful. The Supreme Court found in 2007 that it was unconstitutional. You don't put people in jail and don't provide them bail, or fair bail. You don't provide them a process. So they found it unconstitutional. When he was released in 2006, what the court did was impose very strict conditions. He was on a GPS bracelet. He was he was under house arrest on a GPS bracelet. His wife ended up having to be his guard. He wasn't allowed out without her. His phone and all the computers, everything was intercepted, and the CBSA had him under constant surveillance. It wasn't until 2013 that the GPS ankle bracelet was taken off, but he was still not allowed computers. Oh, he was in 2013 allowed a desktop computer, but in allowing him to use the desktop computer, he had to take it into CBSA regularly to let them go through it and check it to make sure he wasn't doing anything untoward with it. So he's had a computer since at least 2013, but again, subject to CBSA checking everything. He was allowed to have a cell phone, but it couldn't have a SIM card, and you couldn't get a cell phone without a SIM card, and so he never had a cell phone. And that cell phone has proved to be a problem. He still doesn't have a cell phone because CBSA wants to, I think what he's afraid of is if he gets a cell phone, he'll inadvertently do something wrong with it, and he'll end up in breach. And I'll explain to you what happened in the most recent thing. So in July of 2013, when all those conditions were changed, he was allowed out of the house. He didn't have to have the GPS bracelet. Justice Noel found that his compliance had improved and CBSA had improved in the way that it could monitor him. Therefore, he thought they'd get along better, that Mr. Harkat's supposed to get along with the people that are surveilling him. I don't know what he thought, that they were going to be friends, that CBSA was around enough that they'd all become friends. That didn't happen. But in any event, after that, Mr. Harkat has gone back to court a number of times to vary the conditions. They haven't changed in the sense that CBSA monitors what he's doing. They check his computer regularly. He doesn't have a cell phone, but if he had one, they would be able to check that regularly. He's not allowed to leave Ottawa without telling them where he's going. For a long time, he had to have permission to leave. And I want to go through sort of the last points that the federal court dealt with in the most recent iteration of a review of the conditions. The government alleged that Mr. Harkat breached the conditions of release in 2019. In February, they came to court and they said, look, he's breached some of the conditions. And I want to take you through it to show you how petty it is, and I'll try and do it really quickly. And Mr. Harkat, in response, said he hadn't breached the conditions, but in any event, he wanted changes because of a number of things. First, the government, in relying on the continuation of the conditions, is relying on a security assessment that was done in 2009. They have never had the security service update that assessment. So the whole reason for the conditions is that he presents a security threat. We have a security assessment that said the threat was low in 2009 and nothing since. The Supreme Court said you have to be current on threats, like that as more time goes on, the threat dissipates. Well, the threat is never going to dissipate in Mr. Harkat's cases. Every time we go to court, the court says, oh, it's lower, but it's still there. So who knows how low you can go before the conditions can be removed. But it's ludicrous after all these years to expect that they need to examine Mr. Harkat's computer in case he's in touch with some of the extremists. None of the people that they thought he was connected to are in Canada, and most of them aren't even alive. I mean, nobody knows. I mean, how would Mr. Harkat connect with them? Mr. Harkat was not even using a computer when he was made subject to the security certificate, much less would he ever know the emails of the supposed terrorists that he was supposed to have had contact with. But that's the crux of keeping the state control over him, is that he might get in touch with some extremists. And as I said, who does he know? So the government said this is how petty it gets in terms of government intrusion. The government said he deleted emails without consent. CBSA checks his computer. He deletes the emails after he gets his computer back. He thought it was a standing order. The new officer that took over thought it wasn't. The court found no breach. They said he changed his password. When there was a tornado in Ottawa, something happened to his computer. I guess he had it plugged in or something, and he had to re-input the password. He didn't realize that he changed a small letter to a capital letter in the password. And so CBSA, when they wanted to check it like 6 months later, couldn't get in. And at that point, they said to him, you changed your password? He said, no, I didn't. And they made him go back and check it again. And he realized that there was a mistake, that when he'd had to re-input the password after the tornado, that he must have changed the letter in it. The court found that that was not intentional on his part, but even though he didn't know he was doing it, it was still a breach. So the court's got him on a breach. There's one breach, unintentional, but still a breach. She finds that the third one, this is the third allegation that the government made, was that for 2 weeks, Mr. Harkat made 3,000 hits using a private browser, and he's not allowed to use a private browser. 3,000 hits over a 2-week period. He would have been on the computer all the time. The allegation is ludicrous in the first place. We had to get an expert in forensic computers, that kind of thing, in order to get him to check the computer to find out why they thought he was in browsing. It's because the CBSA officer was misreading some symbol that came up in the computer, and it wasn't in private browsing at all. It was some other thing that caused it to be there. In any event, the government accepted that. And what the court does is just pass over it, saying, oh, well, the government decided to withdraw this ground, even though they thought there was still some problems with it. They had to withdraw the ground because they had no case to make. Even their own expert was uncertain about his first conclusions in light of the evidence that our expert found. But that's the kind of detail that Mr. Harkat has to face all the time. And over the years, it's had an emotional impact on him. In 2013, the court recognized that he was already suffering psychological problems from this kind of surveillance and state monitoring and controls. And it's still going on. We can't get the court to change it. And the court controls whether or not a person can appeal the decision. So twice now, in 2017 and just recently this past in 2019, we asked the federal court to let Mr. Harkat appeal from the judgment that maintained these conditions. She wouldn't let us. So he's stuck with the same judge. It's like Sartre's play, No Exit. Forever and ever, you're going to go around in a circle without any exit from the situation that you're in, unless we find another way out of it. And we have several options, but we haven't finalized sort of how we're going to do it. But I also want to say, I want to note a couple of things that the court said in its reasons, and then I'll leave it and let the other people talk. What the court said was that in terms of CBSA was upset with Mr. Harkat because he wouldn't tell them the information about his employer's telephone, the make and model of the telephone of the employer that he was using, that he was allowed to use by the court. What he had to do under the terms of the court order was tell the employer if the employer thought he was breaching a condition, the employer should contact CBSA and he gave them CBSA's number. They wanted the employer to confirm that he had done that, even though he had signed the statement the court wanted him to sign, confirming it. So when it comes to court, the court's not upset with CBSA for asking him to do things that aren't part of the order. The court's upset with Mr. Harkat's failure to abide by the spirit of the order. He's subject to state controls, and the court is upset with him because he insisted on compliance with the terms of the court's order, that he didn't have to go beyond the court order, and the court gets upset with him because he wasn't nice about it. And that's the same thing you get from Justice Noel's previous decision, that now Mr. Harkat's played nice and therefore we're going to be nicer to him. It's like infantilizing the person through the court process. So that's one thing that Justice Roussel said in her reasons. The other that was of concern is she says, I noted that Mr. Harkat had complied with his conditions of release. She's talking about her previous decision that she had made since 2006. And that in order to fully embrace the values of his adopted country, it was important that he be given the opportunity to obtain gainful employment. There was no evidence that Mr. Harkat shared the values of Canada or didn't share the values of Canada. There was no evidence whatsoever. It's the court patronizing Mr. Harkat in the sense that she's benignly assisting him to develop Canadian values through the imposition of state controls over his life. That's the kind of problem that's still there. When we first started with these, I'll close with this part, with the security certificate cases, the 5 Muslim men that were subject to security certificates, Jesus came out with a report in the middle of the summer that we were trying to get them all released, saying that they had studied the question, and once a terrorist, an Islamic terrorist, always an Islamic terrorist. You could never change your views. They never would change their views. They were always going to be the same. And that's the way I think both the court and CSIS continue to operate in terms of handling these cases. It is incredibly dismissive of Mr. Harkat as a person, of the 20 years that he's lived in Canada peacefully, of the family that he's established here, and of his life. I mean, it's just, there's no basis for anything. In my view, there is no legal justification for continuation of the kind of restrictions that have been imposed on him by the court at this point. So that's sort of what I wanted to say.
Thank you. Thank you so much. And we'll have a chance at the end for people to ask some questions. And now we'll move on to Matthew Behrens. If you could put your video on, and then we should be able to see you.
Okay. Can people hear? You can hear me? Oh, awesome. Great. Thank you. And thanks, Barb. And I see a lot of people, you know, Barb and Barney and Beth and Ria and so many people and Joe who have been part of this for so many decades as well. It's really critical that these cases have gone forward in a context in which folks who are not necessarily the target community, the racialized community, are showing support and solidarity, fearlessly putting forward their houses, their RRSPs, whatever, to help get these guys out of jail. And I wanted to just reflect on what Barb was talking about, because I remember we were in court the day that they brought up this report that said, once a terrorist, always a terrorist. And when we actually went home and Googled it, it was based on a Washington Post story. This is how CSIS does their research. And in the Washington Post story, they tracked about 60 releases from Guantanamo Bay. And they found that 2 out of about 60 of these guys apparently wound up back in what was referred to as the so-called field of battle. We're not exactly sure how that's defined, but 2 out of 60. So this notion that once a terrorist, always a terrorist was based on pretty long odds. What I was hoping to talk about a little bit tonight was building on what Barb was talking about. There's this racialized lens through which these so-called state security cases proceed. And there's a lot of white framing that takes place. I guess that's kind of like white splaining, but white framing. And part of my frustration over the years working on these cases is the fact that a lot of the so-called civil society groups, NGOs and whatnot, have been very slow to respond to the racialized aspects, the religious profiling that takes place in these cases. And back just after the attacks of September 11th, 2001, George Radwanski, who was the privacy commissioner at the time, he was one of the people speaking out against the anti-terrorism bill that was then before Parliament. It was called C-36. And a lot of Canadians were up in arms about this and saying this is a horrible, horrible thing, because there was a sense that people outside of the normal range of targeting were going to be affected, people who are part of peace groups or peace and social justice organizations. And once it was clear that they weren't actually necessarily the target, a lot of that opposition disappeared. And at the time, Radwanski was asked, you know, how do you feel about this legislation? And he said, I wanted to share this quote. He said, we're not a society where the police can stop you on the street and say, your papers, please. Because he said, this is not where we want to go, because we're not that kind of society. And I use the term white framing because George Radwanski is not a young black youth walking in Rexdale and being stopped 4 times a day by the Toronto police. Over a 4-year period in Toronto, the Toronto police carded, which is to say they stopped, interrogated, surveilled, harassed, and often arrested 1.8 million people in the city of Toronto. And so in the city of Toronto, we do have a society, and in Ottawa too, and across this country where police act as an occupying force. Police build these massive databases. And so if you are Black or South Asian or Muslim, Arabic Muslim, and you want to go to the United States and you were one of those people who was carded, chances are, if you try and cross the border, that information has already been shared with the United States border officials. And so when we talk about over-policing, this is how it works. It starts with one thing and then it starts to build. And if you are someone without status or you're trying to get refugee claim heard in Canada, what CSIS will often do is approach you and try and convince you to spy on your community to speed up your refugee claim. And if you say no, CSIS might say, well, we know you have relatives in Jordan or in Syria, and we can make it hard for them if you don't cooperate with us. So we do have a police state for certain individuals who are in this country. When we look at that over-policing, Black people in Canada make up 7.3% of federal inmates in the penitentiary system. And they're only 3.5% of the population. And it's far worse. The most over-incarcerated group of people in this country are Indigenous people. The correctional investigator put out a report in January of 2020 and found that Indigenous women make up 42% of the federal prison population for women. And they're 2.5% of the population. And it's very similar for Indigenous men, who make up about 30% of the population as well. And as over the years, looking at security certificate cases, it really forced me in answer to a lot of questions that people used to ask by saying, is this Canada? Is this really Canada where these kinds of abuses are taking place? Is to look at the history of this country and to come to an understanding that we are a country built, in addition to genocide, on indefinite detention. Even before Confederation, anyone who was a dissenter was treated often to indefinite detention in this country. And in addition to the indefinite detention that we see, especially of immigrants and refugees and those who have been criminalized and securitized by the Canadian government, we see this increasingly with Indigenous people who were the first mass group of people who were subject to indefinite detention on the reserve system. They were subject to the first kidnapping and rendering to torture program, which was called residential schools. And we also know that there were concentration camps in this country in the First and Second World Wars. And coming into the Cold War, the Canadian government actually had lists of thousands of people in this country who they would round up because they were associated with social justice organizations, and because of that association were seen as someone who might be a communist and therefore a threat. One of the pieces of legislation which was often used coming out of the 1930s and 40s was dangerous offender or habitual offender legislation. And I've been doing a lot of work the past 4 or 5 years on the fact that the great majority of dangerous offenders, especially in the prairies, are Indigenous people. And when you actually stop to look at their cases, they sound and smell a lot like security certificate cases. So for example, I'm working on the case of one gentleman who has been behind bars for 14 years simply because he brandished a knife. He didn't actually put it to anyone's face. He brandished a knife to break up a bar fight in something that took place over about a 90-second period. He was trying to stop white men who were beating up on his younger brother. And when they all went outside, the police showed up and they arrested him, even though the younger brother was being beaten up by the two white men on the top of a car. And so for 4 years, this gentleman, his name is Andy, was on remand. And during that time, it went from, we'll offer you 9 months in a provincial jail, to suddenly, because he had a lengthy criminal record, because he comes from an over-policed community, he was suddenly, with the judge's encouragement, declared a dangerous offender. How do they declare someone a dangerous offender in this country? Well, in the same way that with security certificates, it relies on CSIS analyzing a certain individual and coming up with a notion of thought crime. For example, in the Harkat case, CSIS says, we have reasonable grounds to believe that Harkat is, was, or may be a sleeper cell who could be activated at some point in the future. So it's based on thought crime, future thought crime. The same process is used in a danger offender proceeding, in which they go to psychiatrists and psychologists to conduct assessments of Indigenous people who are behind bars to determine whether or not they meet psychopathy standards. And these tests were developed not to determine future risk. They were developed to look at whether or not someone had a personality disorder, and they were based on the standard white male offender, and yet they now use them against Indigenous people and always have. In 2018, the Supreme Court of Canada in the Ewart case actually said that Corrections Canada was violating its own legal commitments to provide accurate information on the individuals that it was assessing. 2 years later, none of that has happened. In Andy's case, he was being assessed by a guy over the course of a few hours, literally over a couple of days. In the old days, when people were assessed, they were given a 30 to 60-day psychiatric assessment stay in another institution. But now these things are literally just a few hours, and they're based on racial stereotyping, and they're based on assumptions about past records, which have nothing to do with who you are as a person. They're based on the fact that I have a long criminal record because I happen to be Black or I happen to be Indigenous. Now, the Canadian government argues that it is not indefinite detention in the exact same way they argued that when Hassan Almri and Mohamed Harkat were being detained, that they were not indefinitely detained, because they say, oh, they have the benefit of a detention review. And you just heard Barb's assessment of how ridiculous the detention reviews are. Well, every 2 years when you're a dangerous offender, you can go before the Parole Board of Canada, and the Parole Board of Canada says, well, this is interesting and this is interesting, but the fact is you're a dangerous offender and you have a long record, and that remains the scarlet letter in the same way that the security certificate is a scarlet letter. When Andy was declared a dangerous offender in 2010, he begged for a lawyer to have him represented at this hearing, because a dangerous offender status is the equivalent of a death penalty. You go to jail for the rest of your life and you have no chance of ever getting out. And the judge was tired with him saying, you know, I've given you plenty of opportunities to get counsel. Well, I'm not sure if any of you have ever been in prison and you've tried to call out, but you only have a certain number of minutes on your phone card before the phone cuts off. And I spent most of this summer dealing with Alberta legal aid on a number of cases. And sometimes it takes an hour to 2 hours to actually get through to somebody. If you have a 30-minute cutoff, you lose that opportunity to speak to somebody at legal aid, and then you have to start the process again, and the 30 minutes starts ticking. So this notion that it should be very easy for you to instruct and retain counsel is just complete BS. So ultimately, and I'll kind of bring it to a close here. What I'm seeing is that what we have seen with Mo Harkat's case is something that we have seen since the dawn of settler interventions on this continent. This is something that has a very, very long history, whether we're talking about the mass detention of Japanese Canadians during the Second World War, which was also something that Mr. Radwanski kind of try to water down, because he said at the time in 2001, yes, it was bad, but at least it came to an end, as if that was okay, when in fact, it's never okay. But he said, you know, with these new technologies, these detentions will never end and the surveillance will never end either. So ultimately, how do we deal with this? I think with some of these folks who are Indigenous, who are dangerous offenders, so-called, we're trying to build campaigns of support now in the same way that we've done that with the security certificate detainees. I see Barney from Owen Sound is on tonight, and Barney and his dearly missed Liz, they used to write postcards to the gentleman in solitary confinement every month for years and years and years on end. They would come into Toronto and spend days and weeks on end sitting on those hard benches in the federal court when Barb was up there fighting these cases. And it really made a difference for those white judges to look into and see a whole bunch of white people, many of them seniors, who were there to support these individuals who were deemed the worst of the worst. It's really critical to look at I know we're in a post-evidence, post-fact age, but when you actually look at the evidence and the facts, if you look at everyone that CSIS and the RCMP declared was dangerous, declared a terrorist in the last 20 years, and you look at how many of them, almost all of them, were found to be not terrorists, were found to be victims of racial profiling, many of whom were tortured as a result of this, the numbers are staggering. And yet the federal courts and the federal government, they continue to take CSIS at its word. So ultimately, I guess all we can really ask for is basic rule of law. We need to hold CSIS to account, and I believe Tim is going to address some of this in his remarks, but CSIS continually violates the law, and recent legislation has enabled that. But the Trudeau government also violates the law. One thing that we haven't discussed yet this evening is the fact that Mo Harkat faces deportation to torture, which is illegal under the Convention Against Torture. It's illegal under the Immigration and Refugee Protection Act. It's illegal under the Criminal Code of Canada. And Justin Trudeau says no one ever deserves to be tortured. But so why are we deporting him to a situation of torture? So if we are a country of the rule of law, which is a very problematic term, the rule of law would declare that Mo's deportation to torture should end. His indefinite detention under these horrible conditions should end. And Trudeau should start looking at other places where he himself is violating the rule of law. Tonight marks 1,694 days since the Canadian Human Rights Tribunal declared that the federal government has been racially discriminating against 167,000 Indigenous children. And in that ruling in 2016, they said the Canadian government has been willful and reckless in its racist discrimination. And it's that racist discrimination, it's the child welfare system, it's the kidnapping of Indigenous children that still goes on, that leads to folks like Andy eventually being thrown into prison. So we hopefully, as we do this work and we go forward in supporting Mo, we can also look at supporting him in this broader context that says Mo's case is not an aberration. Mo's case is the system standard operating procedure, and we need to ultimately question the nature and the operations of this system. Otherwise, we're going to be fighting these cases till the end of time. So thank you so much.
Thank you very much, Matt. That was great. We're going to ask, and I put your information on the side in the chat, but I'll post the poster at the end as well, okay? And we'll ask Tim if he could turn on his video, and he'll join us next as our next speaker.
Great. Can everyone see me? Hear me okay?
Yes.
Great. Perfect. Well, thanks so much for inviting me to speak tonight and share our work at the International Civil Liberties Monitoring Group. And thanks so much to Barbara and to Matthew. The work that they do is so indispensable. And I can't wait to hear Azeezah speak too, because the work that she's been doing is just so incredible in fighting what I think, you know, we're here to talk about tonight, and what Azeezah and what Barbara and Matthew have already pointed to is the racist and colonial underpinnings of national security in Canada, and the importance to look at it in the context of policing in Canada, of law enforcement in Canada, and not to, along with the white framing that Matthew was speaking about, I think it's easy to think that national security is in its own bubble sometimes, and that it doesn't have an interaction with what people view as regular day-to-day policing and law enforcement. But really there's a continuation and a link between the work that CSIS does, the Canadian Security and Intelligence Service, which I'm sure everyone is probably familiar with, is Canada's domestic surveillance and spy agency, and the work that they do with the RCMP and in coordinating spying and surveilling people both within Canada and outside of Canada. So what I was hoping to add a little bit is some of the laws and the legal framework and some of the policy issues that have led to this and continue to propagate this racist and Islamophobic national security system that we see in Canada. Just for those of you who might not be familiar with the ICLMG, we're a coalition of 45 groups across Canada, and we work specifically on protecting civil liberties in Canada from the impact of national security and anti-terrorism laws. And we were formed in 2002, following the adoption of Canada's first Anti-Terrorism Act, and in the wake of 9/11, because so many groups recognized that the legislation that was coming through was an attack at that moment on civil liberties in Canada, and also was contributing to and supporting the racial profiling, xenophobia, Islamophobia, and marginalization of so many communities in Canada, and also tied Canada into what was then and continues today, even though we don't frame it as much that way, but the global war on terror, and really following the United States' lead, but other countries' leads in joining this so-called fight against terrorism that was very quickly identified to be fulfilling other goals of the United States in terms of their foreign policy. We can just, I think everyone can point to the war in Iraq, but even the war in Afghanistan, that the reaction wasn't so much about responding to those attacks, but rather to also securing the US's place in the world. And so these groups came together in order to work together, recognizing that any one group could easily be attacked if they were to speak out on these issues. And recognizing that there was going to be a longer fight around this. And so the coalition at the time was much smaller, but we've managed to work our way up to 45 groups that include Canadian Unitarians for Social Justice. And there's a lot of people on the call on the meeting tonight who have been longtime supporters of the work that we do. And so I want to thank all of you for everything that you do, because as a coalition, you know, we're a small organization, but our strength is being able to work with our members. And so I want to thank you for that too. I want to start by talking a little bit about Bill C-36, which was the anti-terrorism law that was first brought in after 9/11 in Canada. It was Canada's first ever anti-terrorism act per se. And one of the things about the anti-terrorism law at the time, and I think it was also framed, and again goes to what Matthew was talking about, this idea of white framing, that it was new. And I think what Matthew touched on is so crucial, that this, you know, we entered into a new phase of national security in Canada and of state security in Canada, but it wasn't the beginning of national security and state security in Canada that targeted and profiled people. And really, we can't separate out the laws that were brought in after 9/11 in Canada from the ongoing push to increase powers for police in terms of policing Indigenous peoples and in terms of policing people of color. And in fact, just months after Bill C-36 was put into law, two of the first people arrested under it were two members of the West Coast Warrior Society, Indigenous activists whose homes were raided by the RCMP and CSIS under a new group called INSET, which is a way for the RCMP and CSIS to collaborate together. Those two individuals were never charged with a crime, but were, you know, faced accusations of being terrorists, all because of their support of Indigenous sovereignty. And so we can see that even from the very beginning, we need to think back and remember that even from the very beginning, these laws weren't only used against this idea of so-called Islamist terrorism, but rather have been used from the beginning against all kinds of groups. But I also want to emphasize, and most of what I'll talk about today is about that, is that really these laws have targeted Muslim people in Canada, Muslim people internationally, and specifically Muslim men in Canada. There's been 15 terrorism prosecutions under the terrorism laws that came in after 9/11 in Canada. As far as from our research, all of them have involved Muslim individuals, whether acquitted or found guilty. And so I think that just goes to show, so on one hand, 15 individuals may say, well, that's not a lot of charges, and that can be contrasted with the breadth of laws, and I'll talk a bit more about how many laws have come in and what it's done to change the framework in Canada. But if we think about it in terms of the amount of violence that we've seen in Canada based on terrorism since 2001, there's been, in terms of what I think the mainstream views as terrorism, I think we could have a whole conversation about why somebody like Alexandre Bissonnette, who murdered 16 people in Quebec City, why those crimes aren't viewed as terrorism, and we can maybe talk about that later on as well. But of those 15, all of them have targeted charges. All have targeted Muslim individuals, and have resulted in a grand total of 2 deaths. And so the amount of resources, the amount of charges, the amount of time that goes into this idea that we need these anti-terrorism laws to keep us safe in Canada, the reality points to a very different situation. So if we look at what's happened since the adoption of Bill C-36, and I think it's important to look back at it too, because of how we don't like to believe that there's been a new normal, but it really did change, and so many things that we accept in terms of policing today and in terms of national security and intelligence today were new back in 2001, 2002, and have been entrenched over the years. So for example, many people today would believe that we've always had a no-fly list in Canada that's used to keep people from boarding planes and traveling without them ever knowing, based on secret evidence that they're never able to access and never able to completely challenge, that can leave people stranded in Canada and leave people stranded internationally. That we know targets a broad range of people, but that the vast majority of those individuals who, again, are affected are are Muslim and Arab individuals, men, their families, and people traveling abroad. And so but that only, oh, sorry. My door just popped open and my cat wandered in. So I'm just going to get rid of, get rid of him and continue. Sorry about that. That's my train of thought. Yes, so for example, the no-fly list, but that was only introduced in the early 2000s. We haven't always had a no-fly list that allows for people to be secretly kept from being able to board flights. And since it was brought in, it's only been strengthened since then through other pieces of legislation, despite efforts from many organizations to confront it. The terrorist entities list. Again, it's a situation where many people would think that the terrorist entities list has always existed in Canada. But again, it's a creation since 2001. And again, we see that of the organizations placed on it, it was only this year that white supremacist groups were placed on that list. And those are international organizations, and it's questionable about whether or not the government has actually used it to take any action against those organizations. But until now, it's been primarily used to target organizations that are linked to, again, for the most part, so-called Islamic and Islamist terrorism. And some may applaud the addition of white supremacist groups, saying that it now shows that we're taking white supremacy seriously as a terrorism threat. But we also have to question the roots of these laws and where they come from. So for example, again, the terrorist entities list allows for groups to be placed on the list with no due process, without access to the information being placed in there, and without an actual ability to challenge their listing. And there's one case in particular of Irfan, a Muslim charity in Canada, that was placed on that list and has had a long drawn out court battle, but essentially can never defend itself because by being on that list, you are not allowed to have, no one is allowed to provide you with material resources. So you can't raise money, you can't get support to hire a lawyer and defend yourself in court. And it essentially left them without any resources to be able to challenge their listing on the terrorism entities list. I wanted to talk some more about security certificates and what they've meant. I think Barb and Matthew both covered it incredibly well, but I think, but it's also, I wanted to talk about how they've been used and how they've grown in order to justify this idea of secret evidence in Canada. So the idea of protected evidence isn't necessarily new since 2001, but the use and breadth of it has increased so much that I think it would, every time we talk to people about it, it really changes their opinion of the Canadian court system when they realize that there's all these mechanisms, including the security certificate system, that allows for the use of evidence that the individual being accused of something can't have access to. And that so-called evidence doesn't actually meet the level of evidence that most people would ever consider it to be. So as Barbara was speaking about what was used in Mo Harkat's case in order to connect him to so-called acts of terrorism, we've seen that in all the cases regarding security certificates over the last 20 years. And what it's done is allowed us now to be in a situation where the government is talking about expanding the idea of national security protected information. And so we know that there's been civil lawsuits brought against the Canadian government regarding, in the cases of Maher Arar and others who were tortured with the complicity of the Canadian government internationally. And those have been mired in issues of the government trying to keep information secret and wondering whether or not if they couldn't disclose information, if it would mean that they would essentially lose the case. And so they've been doing consultations about bringing in further reforms so that in civil suits that they would be able to protect information as being sensitive to national security and to withhold more information So we've seen this grow and just become accepted as this idea that we can have information used in courts that, that the individual being accused doesn't have access to. The solution to that the government and that Matthew and Barbo spoke about has been the idea of special advocates. So lawyers who are able to go in and see the information and act in the public interest, but they aren't the defense lawyers for those who are being accused. And it has been a system that's been valuable insofar as, you know, it does give access to someone to this secret information, but at the same time, it doesn't allow for the accused themselves to defend themselves. And so we're caught in this kind of paradox and a contradiction. For example, with the no-fly list, there is no provision for somebody to be represented or for a special advocate to necessarily be present. And so one of the solutions that some groups have proposed is that we introduce the idea of a special advocate to the no-fly list system, so that when an individual is challenging their listing, if they can't have access to the information, a special advocate type lawyer would have access. And on one hand, that would, in theory, increase the adversarial process and have somebody speaking out in the public interest to be able to review who isn't, you know, either the judge or government counsel. But again, it minimizes the idea of having access. And so what we've tried to argue throughout is that we need a baseline where it isn't that we find these workarounds so that we can better use secret evidence, but that rather individuals who are accused and face, as Mo Harkat does, a potential of deportation or torture, who has lived through these horrendous, conditions of release over the past 20 years, that they deserve to be able to mount their own case. So to tie that back to the idea of how the law is wielded in a way that promotes xenophobia, that promotes Islamophobia, often what we're told is, and what the response is that we need this to protect ourselves, that these laws are necessary and that it isn't based on any kind of racism or Islamophobia. And we could give the benefit of the doubt to people enacting the laws that this isn't their intention, but we need to look at how it's played out. And again, when we look at how these laws are used against individuals, we can see that it's used in the pursuit of a policy that does increase marginalization, that does promote racism, because in the end, it isn't simply how the law is written, but how it's used and what policies it's used to pursue. So when we look at the national security assessments in Canada, we see that it still continues to list Islamic terrorism and adding Khalistani, so Sikh-based terrorism in India, as now the major threats to national security in Canada. Still ignoring, although there are new smaller mentions, but still ignoring other greater domestic threats that pose a much more serious risks and which have caused much more harm and violence in Canada than either of these two so-called national security threats. I think it's also important to look at how many laws have been brought in terms of national security as well in the past 20 years. From our count, there's been a total of 15 national security related anti-terrorism, national security related laws brought in the last 20 years. And perhaps 2 of those have been beneficial to create more accountability. And one of them was the bill that rolled back the ability of the government to revoke someone's citizenship based on terrorism accusations. Sorry, my cat continues to come into the office. Sorry about that. And so we have to ask ourselves, when we see this many 13 bills that increase the national security state, that it give more powers to CSIS, give more powers to the RCMP, give more powers to the Canadian security establishment, we have to wonder, is that proportional to the threat we face? And as my colleague Anne has just mentioned in the chat, we need to contrast it to other forms of violence that we see in Canada. Have there been 15 laws brought in order to combat domestic violence against women? Have there been 15 laws brought in to ensure that Indigenous peoples have access to clean drinking water, medical care? Have there been 15 laws brought in to restrict police from being able to do carding and to racially profile people? We haven't seen that, and these are the things that we know are causing the greatest harm in Canada, and yet we continue this idea, and the government continues to perpetuate the idea that we need these laws in order to keep Canadians safe. And our response would be that, and I think this ties it into what we're seeing right now, and it's something that we've been talking about and many are realizing, that just as we're talking about the need to defund police, that just as we're talking about the need to redirect how we think about security in Canada, we need to be doing that for national security as well. And I want to close by just talking about what we've seen most recently, and to build on what Matthew spoke about regarding how, instead of seeing that movement, what we see is more powers being granted to CSIS and well, especially CSIS, in order to simply cover for the security state. So as Matthew mentioned, just recently there were 2 court decisions that revealed that CSIS had broken the law and misled the courts in their pursuit of search warrants, well, not search warrants rather, but surveillance warrants and investigation of, we assume it isn't completely clear, but it appears to be in their investigation of so-called foreign fighters. And that this happened over the past 8 years. So cases in 2012 in one situation, and in others a little bit later. But we see this pattern of CSIS breaking the law. So one, for example, the most recent in the Peshtari case, that CSIS in the pursuit of a surveillance warrant both lied to the courts about what was in affidavits that were used to support the warrant. So totally misconstrued in order to make it appear that Mr. Peshtari posed more of a threat at the time of the application for the warrant than he did. And that they conducted illegal activities in their pursuit of some of that information that they used to support the warrant. What we saw in the earlier case this summer, the Gleason ruling, was that CSIS had committed unlawful activities in the pursuit of their investigations. For example, and we don't know the total extent, but the examples that we do know include providing material resources to people involved in terrorist organizations in order to continue their investigation. And that at the time of them doing that was illegal. If we go back a little bit further, there was a finding that in 2016 that CSIS had been illegally collecting and retaining information that went beyond what they were allowed to retain because it wasn't related to specific threats. In all those cases, what we've seen is that the government knew that this was happening, knew it was coming, and have passed legislation to now legalize these activities that CSIS was engaged in order to protect them from being pursued after the fact. And so, for example, the collection of information that was revealed in 2016, Bill C-59, the most recent piece of national security legislation, allowed for CSIS to collect and retain and use greater data sets, including information not related to current investigations. Bill C-59 also allows for CSIS to carry out activities that would otherwise be an act or omission, either an unlawful act or an omission that would be unlawful, specifically to allow them to carry out illegal activities in the pursuit of their investigations. And in the Pishtari case, I'm just trying to remember, it was that, well, okay, so in the Pishtari case, they haven't gotten around to actually taking action that would legalize them misleading the courts. But, you know, that would be very difficult for them to do. But we know, again, we see how CSIS is working, has taken actions that would otherwise be unfathomable. If we heard that, for example, and we have heard things like this, that police officers lie to the courts, those cases, you know, hopefully get thrown out and there's a public outcry. There has been some outcry around CSIS lying to the courts, but as far as we know right now, no one has ever been held accountable. And we have to really ask ourselves why that is. And I believe that part of it is because national security has been framed in such a way to make us believe that this threat, and again, it relies on this idea of a threat of foreign entities overseas, of the other threatening Canada, that there's such a threat that we need to undo and undermine these most basic tenets, and that if it happens, it's in the name of our security. And we need to continue, and that's, you know, I'm glad to see so many people here and so many people involved in helping to make sure that this fight continues. So I think I'll leave it there. I didn't talk about Mo's case because others have so articulately spoken about it. But what I will say just in closing is that we have worked closely on Mo's case in order to fight for justice for security certificate for individuals held security certificates, to fight against deportation to torture. And that really the security certificate situation really is emblematic of everything that is problematic with the national security laws in Canada right now. So I'd add my voice to encourage people to donate to the Justice for Harkat campaign and to read more about his case, to share it, and to help make sure that all deportations to torture are ended, and that we recognize this as, you know, an important example and one that we can fight and win in terms of how laws in Canada are being used to target Muslim and Arab men and people of color. And I'll leave it there.
Thanks a lot, Timothy. That's great. So we're going to have Azeezah next. If you could turn on your video. I just wanted to also say, for those of you, you may have noticed that some people have been posting very helpful information and links in the chat function. If you press your chat button on the bottom, you should see it on the right-hand side. And if you want to save those links, you can go to the bottom of your chat on the right-hand side, and there's a word that says file, and beside it on the right are 3 dots. And if you click on the 3 dots, there's a button that says save chat, and it will save it for you into a little file, and you'll be able to find it after the Zoom is over. So keep that in mind if you want to keep that information. So
Lisa, I'm not able to turn on my video. I think the host has to do it for me.
Let's see. Where are you? Can someone see where she is?
No, tain't the case. I just turned on my own video and my own audio.
There, it's working now.
Okay,
it's working now. Thank you.
A little funky tonight, I think. I was having trouble with mine too. Great. So here's Azeezah. Thank you.
Thank you. Good evening, everyone. Assalamu alaikum. Greetings of peace. Thank you to the organizers of this panel. Thank you to my fellow panelists, Barb, Matthew, and Tim, and to all of you. It's an honor to be in the same virtual room as so many people who have been struggling so hard against these abuses that have been happening, despite the cones of invisibility, silence, and indifference that have largely been placed around them. The title of this panel is Homegrown Racism. The very fact that we continuously have to assert and prove that racism in Canada is homegrown, that it is not simply an import or something that is parachuted in from elsewhere. The fact that we continuously, perpetually have to assert and prove over and over again, despite all of the evidence, that racism in Canada is a homegrown phenomenon, is a sign of how deeply the denialism and obscurantism in Canada about the reality of racism runs, that it is continuously represented as something that is merely a side effect or something that is imported from our proximity to the United States. In the wake of the 2017 Quebec mosque massacre, for example, there was immediately an urge to pin this on the effect of the election of Donald Trump in the United States, as if standing behind Alexandre Bissonnette and his firing of that gun was not over a decade and a half of official and public discourse naturalizing the association of Muslims with terrorists and devaluing Muslim life, so that indeed the devaluation and disposability of Muslim life is the entire premise of the war on terror that has been waged in such a way that no one even bothers to keep track of exactly how many hundreds of thousands or even Muslims have been killed, let alone tortured, injured, and maimed. At the time of the Quebec mosque shooting, I was working as an opinion columnist at the Toronto Star. And even after all of the facts had been established and weren't in serious question, I still was not permitted to refer to Alexandre Bissonnette as a murderer because the formal conviction hadn't yet come in. Contrast that to the way that Mohamed Harkat, for example, is continuously referred to as an accused terrorist or a terrorism suspect, despite the fact that he has never been charged with any crime, yet he is continuously referred to in this way in Canadian media headlines. This is a microcosm for the way that racism in Canada operates as a whole, so that Muslims are always considered guilty until proven innocent, and the circumstances are such that that innocence is almost impossible to prove, as Barb and Matt and Tim have so clearly stated. So Muslims are considered guilty until proven innocent, whereas when it comes to whiteness and the Canadian state itself, the presumption is one of innocence, even in the face of overwhelming evidence of guilt. And so contrast the fact that Mohamed Harkat has now been deemed untrustworthy by a court for inadvertently making a minor change to his computer email password, whereas CSIS comes before courts and is found to have lied time and time again, and yet they are still considered a reputable source. While Muslims are preemptively criminalized on the basis of what they might possibly do in the future, the overt and acknowledged breaches of law by security agencies are treated the exact opposite. They are legalized post hoc. As Canadians, we have a tendency to exculpate our country of racism by always looking towards the United States and talking about how great Canada is in comparison. But in reality, Canada has been an innovator of forms of racism that have then subsequently been taken up by the United States. Long before Donald Trump went on his current citizenship stripping spree, Canada introduced through legislation the Strengthening Canadian Citizenship Act, powers for the government to strip citizenship in cases of terrorism convictions. This legislation has subsequently largely now been revoked, but the point is that Trump is now doing what the Canadian government had done long before. Long before Donald Trump introduced in his executive order implementing the Muslim ban, talking about keeping barbaric practices like honor killings out of the United States, Canada had already passed a law called the Zero Tolerance for Barbaric Cultural Practices Act, put forward by the Harper Conservatives, but supported by the Trudeau Liberals, essentially labeling Muslims barbaric and imposing special criminal and immigration measures upon them. The changes to the immigration detention regime, which Trump has implemented in a most draconian fashion, that are being condemned for their severity and their harshness, is simply implementing what Canada has been doing with immigration detention all along, which is indefinitely detaining families for year upon year upon year. Homegrown racism. What else other than racism can we expect to be grown from a soil that is soaked in the blood of Indigenous genocide? A genocidal violence that continues to repeat and perpetuate itself as long as the dispossession and denial of Indigenous sovereignty continues. As we are seeing right now with the tremendous violence being enacted against Haudenosaunee land defenders in what is now called Caledonia at the 1492 Landback Lane. Indigenous land and water defenders being criminalized and kicked off of defending their own ancestral lands. This date, 1492, speaks to the deep historical entanglements and interconnections between the different forms of racism that we are talking about tonight. 1492 is not only the year that Christopher Columbus pseudo-discovered the so-called New World, inaugurating centuries of genocide and ecocide and dispossession. It is also the year that the European conquest of Granada ultimately led to the expulsion of Jewish and Muslim communities from this land where they had lived for centuries in Andalusia, Muslim Spain. These connections between these different forms of racism run deep. The doctrine of discovery, for example, which was used to justify the dispossession of Indigenous nations on this land, has some of its roots in the papal doctrines that were used to justify enslavement and land dispossessions against Muslims and Jews during the Crusades. While the new forms of barbarism and savagery that were pioneered in the settler colonization of the lands of the Americas were then exported back to Europeans' other colonial projects around the world. We see a continuation of this with the contemporary war on terror, with legal precedents that were set during the so-called Indian Wars to justify the suspension of the laws of war that applied between civilized Europeans when fighting and dispossessing and kicking off Indigenous people from their land. Those precedents from the Indian Wars are now being cited to justify the same types of suspensions of the laws of war when fighting the quote-unquote savage terrorists in the war on terror. Conversely, we see now how the national security apparatuses and institutions that have been built up in the name of fighting the threat of Muslim quote-unquote terrorism are also being applied to surveil and subjugate Indigenous land and water defenders. Homegrown racism is not an aberration. It is the racism that is necessary to justify the ongoing violence involved in building a home on stolen native land. We see how these solutions that are generated within the same frameworks and institutions that have created these problems of racism end up being no real solutions at all, but in fact end up perpetuating the very problems that they claim to solve. Mohamed Harkat was released from prison and put under house arrest. And yet instead of leaving the prison, his home has been turned into a prison itself. And we see this time and time again, how supposedly more liberal measures that are introduced, less harsh and coercive measures than criminalization that are introduced by the national security state, far from being a liberalization, end up only further expanding and extending the logics of incarceration and surveillance through Muslim communities and homes. With counter-radicalization programs, for example, which are represented as a more benevolent and benign way of intervening in acts of quote-unquote terrorism before they occur, simply end up putting Muslims under a cone of suspicion and surveillance on the basis of Muslim practices that are deemed to be precursors of terrorism. In some cases, things like wearing traditional clothing or growing a beard. This suspicion of Muslims has been so normalized, the situation is so grotesque that we now celebrate even just the possibility that Muslim kids and Muslim babies who have been put on the no-fly list might have a chance of being taken off. Forget the adults who are also on this list. As Malcolm X said, it's like when someone puts a dagger in your knife 9 inches and takes it out 6 inches, and you are expected to celebrate that as progress. The work of prison abolitionists in the United States and Canada has taught us how so often what is represented as reform simply ends up being the reconfiguration of the very same violences in yet another form. And this is what we have been seeing over and over again with the violences of the national security state. As the great Black theorist Audre Lorde said, the master's tools will never dismantle the master's home. And this is the home from which homegrown Canadian racism is grown. Thank you, everyone, and I look forward to your questions.
Thank you so much, Azeezah. That's wonderful. We would like to take some questions from people, and actually I have one question to start with. And if you are interested in asking a question, first of all, everybody can turn their video on if they want to. And then if you have 3 ways of asking a question. One is to write it in the chat box. We will look at that. And one way is to raise your blue hand. There's a raise your hand on the participant list, and we'll watch for that. And also, if you have your video on, we'll take a look and see if we see you waving your hand if you don't know how to use the buttons. And so the first question is for everybody on the panel. And so you can decide who wants to answer, or maybe you each have part of it. And it's the question is, how does Canada compare to other democratic countries with respect to these anti-terrorism legislation and measures that Canada has done? So who would like to answer that?
Can you turn on your microphone, Barb?
I haven't really studied other countries, and the others may know more than me, but I think that they're pretty comparative in the sense that that Five Eyes group, they all coordinate with each other: Canada, Australia, New Zealand, the United States. I don't know if the United States is part of it anymore, but when Azeezah was talking about the US following Canada, they all follow each other. They take on top, like one will try something and then the others will pick it up and try it. And they have ongoing working groups between the states. So we shouldn't be surprised that it's just, that they have similar laws. I think there was a difference, Azeezah's right in this too, there was a difference between Canada and the States in that the States historically has only gone against people on their own participation in something. Whereas Canada introduced in '92 these broad concepts of your association with an organization was enough to get you thrown out. So they demonize Palestinians and Kurds and Tamils because they're part of a group that has struggled for national liberation. Canada did that first. The US was going after individuals, not the broad categorization. Now the US is going after the broad categorization. So they all learn from each other, but Canada was the forerunner in demonizing entire refugee communities.
It's kind of ironic that in national security discourse, the violence of Muslims is always represented as being internationally interlinked, so that no matter where a terror act occurs, it's always represented as being part of this broader network of violence, whereas the actual relationships and interconnections of violence are between these states that are radicalizing each other with their implementation of progressively more and more draconian counterterrorism legislation. And so when we look, for example, at counterterrorism prosecutions in Canada, and where you have these extraordinarily high sentences for situations where actually no violence has occurred at all. The 2 deaths that Tim mentioned as being caused from quote unquote terrorism in Canada, actually those cases didn't end up being prosecuted because both of the perpetrators were dead, ended up being dead in those situations. And so most of the terrorism prosecutions haven't actually involved any violence at all. When they have involved violence, it's been extremely minor. There was the case, for example, recently of the Canadian Tire attacker who waved a golf club and a knife around in a Canadian Tire. She maybe scratched one person. She was charged with multiple terrorism offenses for waving a golf club around in a Canadian Tire. And so the reason why we see these extremely draconian high sentences when no harm at all has occurred is because courts look to each other and the sentences that are delivered in counterterrorism cases and then feel a pressure to up their sentences. Courts have explicitly said this in one of the first terrorism prosecutions in Canada, the Kawaja case, where his sentence was astronomically increased in order to make it comparable with sentences that have been delivered which had been delivered in the UK. And so while the first terrorism prosecution in Canada elicited a sentence of 6 months, and that was for someone who was accused of funding the Tamil Tigers, all of the sentences since then have been extremely high, and it is precisely because of these international radicalization in counterterrorism policy that is happening.
Any other comments? There's another question here. We have a question for Tim or anyone else who wants to answer it, but Tim specifically. You mentioned the securitization of Sikhs in Canada under suspicion of Khalistani sympathy or activities. We were wondering did this come about during the time of Jagmeet Singh's NDP leadership? She's remembering that when he was first elected, CBC TV asked him about his sympathies with Air India, as if that was a legitimate question.
Mm-hmm. Yeah, that's a really good question. So the inclusion of and securitization of Sikhs in Canada's public security report, public threat report, came in fall 2018, and it actually followed Justin Trudeau's trip to India, where he met with Prime Minister Modi, and so is actually seen more in the context of the Canadian government trying to move forward in building economic and security relations with India. More so than the election of Jackman Singh as the leader of the NDP. But I think it comes in the same context. So the Air India bombing has been something that security hawks in Canada have pointed to justify even before, before more recent laws as a reason to have stronger anti-terrorism laws in Canada. And there's been journalists, and particularly that journalist who interviewed Jackman Singh, who continues to push this idea that there is some existential threat to Canada from Sikh activists. And so it comes in the same context where we don't see violence based on the Khalistani movement and Sikh independence in Canada. But it's easy, and we saw this after 9/11, to say, well, we're worried about the threat of Islamic and Muslim groups, and so we're going to also lump in Sikhs and the Khalistani movement and others into this idea of this overseas threat to the security of Canada. So it's definitely related, but there was intense pushback to that public threat assessment, and the public safety minister at the time, Ralph Goodale, eventually backpedaled. But even though he eventually modified the report and changed some of the language, the sense is still that Canada trying to develop closer relations with such a racist and xenophobic government in India right now under Modi, that this idea that they need to support the persecution of Sikh activists in order to maintain that close relationship remains. And I think that also speaks to this idea of Canada in the international system. So there is the Five Eyes, and the US is still part of it. and they develop policies and share information together. But Canada has continued to play a role internationally in the so-called war on terrorism, and allowing other countries to bring in draconian laws because they say, well, Canada does it too. So Canada adding 6 to their public threat assessment allows other countries to then point to it and say, oh, Canada is even identifying this as a threat. Canada's stance on surveillance, on access to encryption, of maintaining a no-fly list, of having a terrorist entities list, that all plays into the international framework that allows other countries, because Canada bills itself as this defender of civil liberties, of rights and freedoms, to then say, well, if Canada can do it, well, we should continue doing it too. And the Canadian government knows this, and they still persist in these laws.
May I add something on the question of the supposed Sikh terrorism? So in the treatment of Jagmeet Singh, I think we saw really clearly the operation of this double standard. Singh was harassed and pestered about his supposed connections to Sikh terrorism when the links were extremely tenuous. On the other hand, we had Andrew Scheer, whose campaign director was connected with the white supremacist outfit, media outfit, Rebel Media. He was questioned about it once. He left the stage when he was questioned, and no one bothered to pursue the issue. And so right there, we see how clearly this double standard operates in white supremacist violence versus violence that looks like it comes with a turban and a beard. Now, recently, there has been a challenge to the no-fly list listings by 2 people who have been put on because of their alleged links to Khalistani Sikh terrorism. And in the reporting on that, we also see how this trial in the public court functions to criminalize and ascribe guilt to people, which is then very difficult to remove the stain of guilt, no matter what the legal process actually ends up saying. And so effectively, they've been preemptively labeled terrorists in the media through these selective leaks from security agencies, which we see happening time and time again. While it is made extremely difficult for the people who are subject to these criminalizing processes to get any kind of information that would help them to exculpate themselves or to prove their case, on the other hand, we have these selective leaks of information by security agencies that function to criminalize people publicly in the court of the media and the public opinion.
Azeezah, we have a question for you specifically. You did a good job of describing some of the ways in which racially and religiously based injustices are continuing today in Canada. Do you have any ideas about how we could improve this situation? What can be our next steps?
I think that it is so vital that we connect any struggle for racial justice to solidarity with Indigenous peoples, for sovereignty, and towards decolonization, because otherwise what ends up happening is that we try to assert our belonging in a system, in a structure, in a state that is fundamentally problematic, that is built on racism and white supremacy. And so it ends up reproducing those same structures in different form. I see someone's writing in the chat, Carl's writing in the chat, we all live on stolen land. And ultimately, that's the issue, is that in order to justify the ongoing settler colonial project, you have a whole host of different racial discourses that are deployed, and they will continue to be deployed and to regenerate themselves as long as this original sin, this underlying wound upon which Canada has been built, the dispossession and colonization of Indigenous peoples continues. And so many of the solutions when it comes to national security that are proposed involve integrating Muslims more into the system, for example, having more Muslim CSIS or RCMP officers. Well, we know that doesn't work because the lawsuit that was filed against CSIS by former CSIS employees found that the Muslim employees who were there were subject to horrific racism while they were there, and that we know that Muslim RCMP officers have deliberately been used in order to participate in entrapment projects against other vulnerable Muslims. And so clearly just integrating more Muslims into the system, or more of the people who are targeted by the racism into the system, doesn't work when you haven't fundamentally changed anything about those institutions themselves and the logic that they're operating on.
Sorry, I was muted. I had a question here. Well, I'm not sure if it's a question or a comment, but from Carl saying, how might greater inclusion and representation in the military, police, security forces, for example, more women and proportionate people of color, Indigenous people, how could that help to better humanize our legal enforcement communities? And I would say our whole criminal justice system, really. Has anyone got comments on that?
I think Azeezah just answered that.
Yes.
I think that's important, but I also think you have to, like, I think the courts need to be changed too. Like we appear in front of white entitled people, and the liberals think they're doing great because they've appointed more women. That doesn't answer the problem when they're white women who carry the same views as the white men that are on the court, and they are entitled. I mean, it's just, I don't know, it's almost unconscious. There's a certain sort of perspective or view. So it's not just the security situation, it's the courts, it's the officials. But it still comes down to individual training and attitude and approach. And it doesn't matter what race or nationality you are. I do think someone who comes, like if you have a critical mass in the federal court, for example, of people of color, people who come from different backgrounds, that makes a difference. It's got to make a difference, just even in understanding the religious significance of something that CSIS misreads and wouldn't be misread by someone who understood Islam or grew up in Islam, that kind of thing. But you still have to have people who are concerned about the charter, concerned about human rights. You don't just put someone on the court, even if they are Black, if they're going to be, I mean, we've had some Black judges in the federal court that have not been particularly progressive in the way that they've dealt with human rights. So it's still a human rights kind of issue on appointments.
I think sorry, can I respond to that as well?
I was just going to say, in my experience in family court, there's lots of women judges, but they're not helping victims of violence very much. So anyway, go ahead, Azeezah.
So building on that, I think what we see is that the people from the groups who are subjugated by racism or by patriarchy, who are permitted to advance in the system, are the people who are most willing to uphold those very same structures of oppression. There are Muslims who are deeply implicated and involved in advancing Islamophobia. Some of the most prominent Islamophobes are people who come from Muslim backgrounds, and it is precisely because they have this background that they are allowed to speak as experts, even though what they're actually doing is just reproducing the same dominant discourse, but it's coming from a Muslim mouth. And in some ways, this type of racism is even more insidious because it makes it so much more difficult to identify. You can't look at a bench or a media room and say and easily identify that it's racist because there's only white faces in the room. Instead, you have Black and brown faces acting as ventriloquists for the exact same ideas that have been what the dominant discourse is all along. But now it's coming from a greater diversity or a seemingly greater diversity of voices, and so it becomes much more difficult to dismantle racism when it comes with a multicultural face.
If I can just add one thing to that as well, and I think we also need to be calling, like, we've been looking at this idea of CSIS diversifying for a little while now, and the other thing is that completely it's as Azeezah's pointed out, it's the system itself that is rotten, and so having different people in there isn't going to address that. But also those lawsuits, for example, against CSIS by their own employees were in 2005. And recent reports coming out of CSIS, there was another lawsuit afterwards. We've received access to information reports about the process CSIS is taking. And this idea of diversifying is also a distraction. So the problem has been identified, but after 5 years, there's been reports, there's been action plans, there's been committees put together, but has there actually been a change even in CSIS? From the most recent numbers, there hasn't been in the so-called diversity of an organization that is fundamentally supporting these policies that are inherently racist. So there's the issue that the system is rotten, but also this idea of diversifying CSIS, just like diversifying police forces, often is a distraction from actually addressing the problems that persist.
I have a question here from someone else. Is anyone able to talk more about legal challenges to security laws in Canada or in international courts?
I mean, there's more that needs to be done, but like even in Mr. Harkat's case, there'll be more steps taken by him in the future about what's been happening to him. But I don't think I'm not aware of any actual challenges at the moment, except the no-fly list challenges, which are before the court. Tim or Matthew, are you guys on top of that?
Just on our side, I think you're right, Barb. There aren't that many ongoing legal challenges. There have been some. So, for example, the BC Civil Liberties Association filed a legal challenge of the Communication Security Establishment, which is Canada's kind of foreign signals intelligence agency. We haven't even talked about them tonight. So they have a whole other problem. But that's up in the air right now because the government brought in legislation in Bill C-59 to try to head off some of the legal arguments that they've made about the unconstitutionality of CSE's activities. So again, we see legislation being brought in to try to, undercut the questionably illegal, in the CSE's case, it hasn't been proven, but illegal activities that they've taken in the past. So I know the BCCLA hasn't stopped that case from moving forward, but I don't really know the status right now. Last I heard a few months ago was that they were still reviewing it, but they've also been occupied with so many other issues. The Canadian Civil Liberties Association and I believe at the time it was Canadian Journalists for Free Expression had filed a suit against Bill C-51 to challenge aspects of Bill C-51, which was the Harper era bill in 2015, particularly including the no-fly list. But again, that got put on hold when Bill C-59 was introduced, and they're still reviewing what they're going to do with it. So part of it is that these laws keep changing, and these suits take years and years, as we know, to progress through the courts. And the government is finding ways to try to undercut some of that argument by just changing it enough that it might pass muster. We saw that with CSIS's new powers granted in Bill C-51 to undertake threat disruption, which is essentially granted them powers at the time to take on actions that would violate the charter if a judge had approved it, but again, approved in secret, in order to disrupt potential threats. So even before something happens, they would be able to disrupt it. The Liberals didn't get rid of that. They just changed the framework to make it a little more legal for them to do that. And we're not lawyers at ICLMG, but I think that that will at one point become ripe for a court challenge as well.
Is there anybody else? I'm trying to see if there's any other questions. I have someone thought that Chi Popat wanted to ask a question, but I don't see them on my list.
Well, while you're reviewing it, I just wanted to make one note from what was said before, and I can't remember who said it, about CSIS lying to the courts. In Mr. Harkat's case, when I was going back through the decisions that were made before I was involved in it, one of the judges finds that it was unfortunate that the CSIS officers had lied to him under oath in court, but that was because they had also lied to their lawyers, so they didn't get proper advice. So he apologized for them and accepted their evidence over Harkat.
And in Harkat's case, there were two informants, and one of them failed a lie detector test, and the other one was carrying on an affair with the CSIS agent handler. So you know how these things work in relationships, give me more, and I'll give you more. And so these are two witnesses that Judge Noel refused to allow to be cross-examined, even in secret. So the only people who would have been in that court would have been the judge, the witnesses, government counsel, and the special advocates. Neither Mr. Harkat nor his counsel would have been there, but nonetheless, that's a key part of what led to the Supreme Court actually holding a very rare secret session during the appeal of Mohamed Harkat's case. The Supreme Court of Canada actually met in a secret session. So this is part of the problem that we're facing is, as Tim was pointing out, they just keep, biting away and taking another piece. And it gets to the point where we're creating these parallel judicial systems. We've got the racist system, which you can see in public, and the racist system, which goes on behind closed doors.
I have a question here about what kind of resources are available to Mo Harkat to defend himself going forward. Does he qualify for legal aid at this point?
No, we went to court seeking funding because the security certificate cases were all funded. There was a funding order for all of them, and I don't know what happened. They just sort of cut it out at some point. And they wouldn't fund it, and the government opposed it, and the judge found that there was no need to have an experienced lawyer on the case, so she was dismissive of me being involved. But I don't know why she said that, because it didn't matter whether it was an experienced lawyer or an inexperienced lawyer, there was no funding for either.
Yeah, I think a lot of people don't realize that if you get legal aid, you don't get paid anything different if you're young or old, right?
No. And he's just above the line for eligibility for legal aid, but you can't on his kind of income cover the kind of work that needs to be done in these cases. And so it's a constant struggle trying to sort of figure out what to do and how to do it. Like, you have to make choices about what sort of legal steps you take.
Mm-hmm.
So in the chat area, there is a reference that was just posted by Anne. So you can click on that and make a donation online. You can do an e-transfer to support the legal case for Mr. Harkat, or you can write a check to the Justice for Mohamed Harkat Committee.
But the other thing about it is that in terms of the way the court dealt with it, the request for funding orders dates back in the criminal justice system years. It started with Fisher. Fisher needed a lawyer and didn't have the funds to pay for it. And the Supreme Court dealt with it, and other courts across the country have dealt with it. Only in the federal court and only in the security certificate cases did the judges say, well, you can't have government funding because you haven't shown that you couldn't fundraise. Like, why would they assume alleged terrorists need to fundraise and are going to have enough money to support themselves through the case, through all the litigation, when persons who are ordinary criminals aren't required to fundraise or show that they can't fundraise before they get government funding? It's another way of sort of disenfranchising them because they're not regular Canadians, like in Ireland, Northern Ireland, they called them ordinary decent criminals if they weren't political prisoners. That's what they're saying. You're an ordinary decent criminal, you can have funding. If you're not, you don't. You're not one of us.
Yeah. Well, we're coming up to 9 o'clock, and we wanted to be finished by 9 o'clock. So I was going to ask Anita if she wanted to finish up our evening this evening with a few words. And I thank all of you so much for being here tonight. It has meant so much to me. Thanks. So we'll have Anita speak now.
Okay, as chair of the Global Justice Working Group at the First Unitarian Congregation of Ottawa, I would like to thank all you excellent speakers. It's so great to be in the company of leaders who care so much about justice issues. Mo Harkat has suffered long enough from the assumptions of being a terrorist and the actions of CSIS. And the threat of deportation has to stop. Mo belongs in Canada. I would also like to announce that on September 24th, we have a Holton lecture to celebrate the fact that United Nations is turning 75 years old this fall. So hope you will come to that one too. So thank you very much, all the speakers. I really think you were all very excellent. Thank you so much.
Thanks.
Great. Thanks a lot, everybody. And I hope everybody has a good night.